Digital tea and Vicky's.
Yeah, digital tea. Hello. We've got people coming through. Excellent. Welcome to this afternoon's session of this committee. Do I need to go back through the whole process, or we just introduce the witnesses? Okay. So Chris, Darcy and Tim, what I will do, I will get you to state your name, your position title, and swear either an oath or affirmation. And I'll start with Chris.
I'm Chairman of Southern Riverina Irrigators.
And the oath or affirmation, Chris?
Oath, please.
Have you got it?
You should, but if not, that's...
have you got the oath there?
I have not, sorry.
Well, you haven't? I'll get you to repeat after me. You right?
Yep.
I swear that the evidence now about to be given by me.
I swear that the evidence now about to be given by me
shall be the truth, the whole truth, and nothing but the truth.
Shall be the truth, the whole truth, and nothing but the truth.
So help me God.
So help me God.
Thanks, Chris.
You're welcome.
Darcy?
Yeah, Darcy Hare, Vice Chair of Southern Riverina Irrigators. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thanks, Darcy. And Tim?
Tim Horne, lawyer of Aqualaw. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. And just before we progress on to our opening statement, I've just received a text message from Greg Donnelly saying he doesn't have a link, so could the Secretary sort that?
Oh, of course.
Okay, thank you. Now, would each of you like to make a short, brief opening statement? And if so, start with Chris.
Mick, look, we have major problems. We have no problem with the control of licensed water where people like ourselves own a licence from a structure where there is an allocation of water, where they bought a licence and pay for it, and when those storages are filled, they're allocated accordingly. Unfortunately, in our case, because we have complied and we do have a licence and we have works orders supplying water to our properties, we're being adversely affected by the unreasonable take and the uncontrolled take of the volumes of water in the north. And there is rules that apply to all of New South Wales, and for too long they haven't applied to the northern regions. And there are so many factors like the volumes and the controls and metering that and compliance with works that haven't happened. And we've seen such a massive increase in the take, as is evident from the, a simple meter like at Wilcannia, that it's dropped substantially, and we would estimate by that figure 4,000 gigs. Now, that has a massive impact on downstream users, for critical human needs, for massive environmental damage to wetland places like Menindee Lakes and Macquarie Marshes. And there's been 20 years of demands to meter these and control these that hasn't happened and hasn't been enforced. Since the basin plan was implemented in 2012, the Liberal National Party of New South Wales have not actually complied with all of the requirements of the basin plan or put the meters in place. And the extraction now is having massive impacts not only on environment downstream, but because there is no water going into those lakes and making no contribution down the Darling River to South Australia's requirement, it's negatively impacting our allocation. They're now taking all of the water out of our storages downstream, which is again having massive environmental impacts all the way down the river and destroying, again, Ramsar listed wetlands like the Barmah Forest, destroying trees and wildlife and fish all the way along the river to make up the volume that is demanded into South Australia and downstream. We've been patient for this process to be implemented. They're out of time, and to put in place a regulation to give these guys further extension and to give them an amnesty for taking water without a licence is just intolerable for us, and we have no choice but to to make this objection as strongly as we can and ask that the New South Wales government please disallow this motion and consider all irrigators, environment and other users downstream in New South Wales.
Thanks, Chris. So Darcy or Tim?
Yeah, thanks, Mick. I'd just like to endorse what Chris has said there. Also, like we talk about this being unregulated take with floodplain harvesting, and the MDBA did a compliance report in 2017 and said that the Northern Basin and we are I know we're focusing on New South Wales issues, but it talks about the Northern Basin floodplain harvesting compliance being 29%, and we sort of flick back to the Southern Basin. And we're sitting on about that 84% compliance of all of our take. So, when we sort of couple those together and we see a relaxing or an exemption for works orders and the fact that there's no licenses for floodplain harvesting yet, it sort of puts you at a bit of loggerheads when you're in the same state and these completely different set of rules apply for when you're looking to take water. And when the taking of that water is at the unregulated approach that it is now, it's having a massive impact on communities in the Murray Valley. That's where we're coming from. We used to get the 39% coming down the Darling, and now we've got about a third of the water now flowing down the Darling, and that's having massive impacts because of these agreements that New South Wales is party to, being the Murray-Darling Basin Agreement. Thanks, Mick.
Thanks, Darcy. Tim? So, Tim, you're muted. We're just going to work.
Have you got me?
Yep, we're right. Away you go.
We've just circulated some supplementary submissions just in response to a lot of the other submissions before the committee. I think that every single person who's submitted something to the committee is in agreement that floodplain harvesting needs to be licensed as soon as possible. However,
yeah. We've got someone, Tim, I can just interrupt you there. We've got someone dialed in who hasn't been identified. Who was that that's just come in?
Oh, it's Catherine Cusack.
Oh, Catherine. It's come up identified, caller in user. No, that's good. Thanks, Catherine. Sorry,
No
Tim,
worries.
keep
I'll
going.
just go on mute. Thank you.
Sorry.
Yeah, you're right. Keep going, Tim.
Yep. So I think most of the people who have submitted, made submissions to the committee have recognised the huge impacts of floodplain harvesting and how important and urgent it is that these matters are addressed. However, there really has been a lack of any justification for the regulation. There doesn't appear to have been any strong submissions as to why it was so urgent, why there was no consultation with the community. There's been no clarity around what was the position before the regulation with respect to all of these, forms of take. It just seems to be quite ad hoc and is not the appropriate way to deal with what is a significant issue across the entire basin.
Okay, thanks, Tim. So committee members are going to text in if they've got questions, and the first one on the list is Sam. So Sam Farraway, you've got the opening over.
Hi, Dad.
Thank you, Mr. Chair. I've just got a few
I'm just in committee at the moment. So. Oh, okay.
Can we,
The other.
Can you mute, Robert? Thank you. Okay. So I've got a couple of questions. And I haven't been able to read through your supplementary briefing that's only just come in, so excuse me for that. But just to Tim from Aqualaw, in your view, does floodplain harvesting occur in the south?
Does it occur?
Yes.
I don't think that's the point of this this review, is it? Or
it's around the regulation of floodplain harvesting.
Yeah.
No, it's not, though. It's a short answer. There's none in the Murray Valley of Murray Irrigation Limited that I'm aware of. It is controlled and licensed, and it's illegal to take water via any method without a works order or a license and an allocation.
So, so any framework that is being looked at as part of this regulation that is being essentially established for the north, should that be replicated, do you think, in the southern basin?
It is presently in place, and we all comply with the works order and a license and the water allocation that we've bought. The problem is that we're getting a zero allocation because there's no water coming down from the north, and it's not being metered or monitored or controlled in any way, and it's reducing the flows into the Murray by about 4,000 gigalitres per annum.
So just a question that I wanted just to direct to Tim. How, in your view, how much water do you think is taken during a typical floodplain harvesting event?
Well, what is a typical floodplain harvesting event? I mean, and without any proper monitoring and metering, it's impossible for anyone to give you a really clear answer.
Sam, sorry, Mick. Sam, if I could just attempt to answer that, going back to that 2017 compliance review that I mentioned earlier, it actually gives like an average annual take in the northern and the southern basin. And it looks at an average take from 12-13 to 15-16. If you go by that sort of 85% compliance within the southern basin, then you look at the northern basin where you've got that sort of 30% compliance. If you and this isn't a part of our supplementary submissions, this is just I thought I'd just given you a question. It looks like there's about 3,000 gigalitres in this 4-year period on average of unmetered take in the northern basin. So that's just off that 2017 MDBA compliance review. I can flick that to, I don't know how this sort of thing works, but I can flick that through later on if that suits.
Yeah, what we'll do, Darcy, is we'll treat that as a question on notice, and the Secretary will get in touch with you and you can provide that as a response.
So just a very quick follow-up to, probably to Chris, I suspect, for this one. So Tim has said that there isn't generally a normal floodplain harvesting event, but obviously there's articles publicly available in the media. So is it contradicting the view? Because I think you've made comment in media around a normal floodplain harvesting event could take 3,000 gigalitres in an average event. So is Tim wrong, or in your view, and I think Darcy just touched on it then. So
no, I didn't say in an average event. I think what we were saying is the annual take, but in a rainfall event like we just had earlier in the year when Minister Pavey used her powers to lift that embargo. I think there is a report that she estimated 20,000 megs and DPI supported her with 30,000 megs, but we would contend on evidence that we would like to submit that it was closer to 900,000 megalitres were taken in that rainfall event in the early part of this year.
And just for context, when I was doing a bit of research around today's inquiry, I found obviously an article in the Land 27th of March last year, and it quotes you as saying by simply calculating the amount of cotton grown, the take in the state's north by floodplain harvesters would have to be 3,000 gigalitres.
Yes, that would have been the case.
So, yeah. Well, I've got a few more questions, but I might hand over to someone else, Mick, just so everyone can get a bit of a go.
Thanks, Sam. And before I go on to Robert, I just want to clarify. So, Chris, you said you had some information you wanted to present as well. Is that the same information that Darcy is going to provide to us?
No, it's quite separate information that is not quite complete, but the volume of water that we would contend was taken in this most recent rainfall event was closer to 900 gigalitres, and we'd be happy to submit that information when it is finished.
Okay, yes, please. We'll take that as a question on notice, and the Secretary will get in touch with you. Okay, thanks, Chris. Robert.
This one to you, Chris. Why did Kelty not make any comment in his floodplain harvest reports, north and south?
Well, we were concerned about this, and it was an issue when he came down to do the Southern Basin review, and I put that question, and I suppose it is a question for him. But his response to me when he came to the south was that in the northern region, floodplain harvesting was not an issue. Subsequently, it wasn't raised with him, and subsequently he didn't mention it in his report. However, he did contend that it was an issue for us because he could see how the hydraulics were negatively impacting our reliability, where we had an average of 88.5% reliability for our allocation against the licences we held on the Murray River for a 42-year period, I think. And that has been zero for 2 years, or 3% last year, and it's zero at the moment. But that's where it's impacting us. And we raised that with Kelty, and we pointed out how it's negatively impacting our region. And still, he chose not to make any mention of it in the review that he did, to any extent, other than say it should be meted, which is obvious.
Do you have a view, or maybe to you, Darcy, do you have a view on what the purpose of this regulation is all about, the one we're currently discussing?
I think it's to allow more floodplain harvesting to occur for people that never sought or never had works approvals before the 3rd of July. We know that there's been a massive amount of development happening up in the Northern Basin with floodplain harvesting works for increased take for the last 27 years. And nobody's prepared to put a number on that. Like you've got the NRC have said that there's 4,039 gigalitres of storage. You've got the DPIE's come out and said, and New South Wales Irrigators Council has commented on a number of times, being an advocate in that space, that there's only 1,400 gigalitres of storage. So it's one of those areas that's of hot contention. And I think they wanted to take as much as they could in this time frame without worrying about downstream requirements.
And we heard evidence this morning from, I think it was the New South Wales water people. I can't remember quite the terminology there, that this was an interim measure and that it was necessary. But when they were quizzed about what it was all about, they didn't seem to know. They just kept saying that the department or the minister's office was saying this was necessarily had to be done in relation to or before new legislation could be brought in July next year. Are you suggesting that this is a delaying tactic to allow for more works to be done?
Absolutely.
Yeah, I would think so.
Chris, is that what you're saying?
Oh, absolutely, Robert. It has been a contentious issue for some time, and we've been able to establish facts and data based on that simple cotton crop that Sam was mentioning there. Knowing the volume of cotton that was produced in a year when there was no rainfall, there was no allocation from the rivers, and there was very little water available from bores, they were able to still produce a volume of cotton that would have required 3 million megalitres. Now, just to put things in perspective, the Basin Plan has spent $13 billion of taxpayers' money designing a system where they take all of the water, they allocate it to the states, and the intention was to remove about 3 million megalitres of water for the environment. And during that same time frame, because there has been no regulation or control or monitoring or metering of the water in the north by New South Wales government, that there is that same 3 million megalitres of water has been taken from the north. So you've had a zero effect, and it is having a major impact on our region because all of our water is supplying the environment downstream.
Is there any reason at all why they should not immediately implement the sort of controls and licensing arrangements on floodplain harvesting in the Northern Basin that you talk about, other than what you're just mentioning now?
Well, I'm saying that it absolutely has to come to a head, and right now they have filled their storages from this recent take, and this regulation allowed them to take massive volumes of that water without any fear of any conviction. They have a full storage. They have sufficient to grow a crop. This is supposed to be implemented next year, and if this regulation is removed, it actually forces the whole process to go ahead, to be monitored and see who is complying with works orders so they can determine who can be given a licence, and then they're compliant with the rest of the state.
Well, that leads interestingly to my next question, and that is, when was the last time an audit was done in relation to these works orders in the Northern Basin, or indeed even in the Southern Basin? But let's start with the Northern. Are you aware of when that?
I'm aware of an audit in the Five Valleys that was done in 2008, Robert, and it was, but they've since that period when they were trying to identify the volume of take, which I might add staggered New South Wales government officials that did it. They've since spent another $17 million on LiDAR satellite investigation to, I don't know why, but clarify that take and see what it has grown to. It's still...
Sorry, is that March 2008, and that's why they're seeking to exempt all work since then?
Exactly. We know damn well there's been massive construction ever since then, and at all times there was specific volumes set by the Murray-Darling Basin Plan. There's been specific volumes set by the 93-94 take, and it still continues unabated, unchecked, uncontrolled, and it is just unacceptable, and we would contend it's unlawful.
Some have been contending that it in fact was lawful under the 1912 Act. You want to comment on that?
Tim, if you'd like to explain that difference in the 2000, it was repealed.
As a general proposition, under the Water Act 1912, there was the opportunity for people to apply for licences. We understand that New South Wales has not issued any floodplain harvesting licences, and that a lot of irrigators are relying on the fact that it was, I guess, technically inbuilt into a works approval application. How many of these applications or works approvals have been renewed subsequent to this, we do not know. But certainly under the Water Management Act, it is very clear, and a lot of these subsequent works that fall under the Water Management Act, if they are used for the purposes of floodplain harvesting, they're doing so illegally.
In general terms, the evidence we got this morning coming from, I think, Namoya and also from the other state, I guess, Northern Basin Water Association, sorry, I just can't quite remember the name. They said they had no problem with licensing properly and dealing with it going forward, but we just didn't seem to get much out of them in relation to what they thought should be happening at the moment and what the purpose of this regulation is. Tim, do you, from a legal standpoint, have a view on the purpose of this reg?
Well, I do. It's very clear that with this regulation in place, there is no incentive to to conclude the licensing process, especially in circumstances, and I raised it with the GVIA submission, that they even note that once the licensing regime comes in, it will improve flows, and that can only be a case of that the licensing is going to restrict the amount of water that's being extracted currently. That's the only way that it could be improved. So this regulation really just allows this situation to go on indefinitely. The MDBA also in its submission was very clear that this has the regulation has a substantial impact on all water users unless the reform agenda is done in a timely manner. But this floodplain harvesting issue has been, at least since the State Water Management Outcomes Plan of 2002, but I mean, it's been identified as an issue going back to 1995 and the introduction of the cap. So we have a little reservation, or SRI is concerned that this will not be resolved in a timely manner. The 2008 line in the sand that is referred to proportionately reduce or license it back to the 94 levels of extraction as at the 2008 levels of development, that disproportionately affects people who did no subsequent developments post 1994. And that will also be a major issue for New South Wales to deal with. So we don't see it proceeding in a simple manner. However, if the Northern Basin or if New South Wales is extremely confident that it can resolve it, then the regulation isn't necessary. The dams are full, and we should withdraw the regulation and allow them to finalise their floodplain harvesting licensing
Yeah,
process.
look, you hit the nail on the head. I mean, the dams are full, but the Murray-Darling Murray-Darling Basin farmers are still on zero allocation.
Correct.
How does that work after a rain event in February that actually is continuing on and off since then? The whole process just doesn't seem to make any sense. I think, look, the reality in your comments, I think the right one, the reality is that there is no incentive to finalise this because there's no sunset, for example, on this regulation. It can run indefinitely, as far as I understand it.
Robert, the concern we have, just to put things in perspective, is when there's a zero allocation in the south, and I mean, I think the registered farms that have applied for on-farm floodplain harvesting are about 1,340 or 1,350. And putting it in perspective, there's in excess of 10,000 farms, irrigation farms in the south along the Murrumbidgee, Murray and Goulburn that are all impacted by this massive water take. And we had a socio-economic impact study done, commissioned by the Australian Institute, that would show the difference in the economic income for the people in the north that are growing the crops with this water that they're taking of almost 4 million bales of cotton would be an income for export of $2 billion worth of cotton. Now, the economic impact on the production and the value-added communities in the south is closer to $25 billion. That's a 1.5% of Australia's GDP, because there's no water, no volume of water getting down to where people actually have a licence and are expecting a reasonable allocation.
So, as far as this, let's call it lack of regulation in the north, is concerned, is it any worse now than what it was under Labor? Because this process has been going on for over 30 years.
It's getting worse as we speak because the construction and the expansion of the dams and the storage and the capacity of pumps is continuing unchecked, and worse than that, the on-farm efficiency program of the federal governments is actually funding the constructions of these dams without a works order, without a licence to take additional water out of the system that we would contend is owned by people who have a licence for it, that have complied with all the rules. Now, the difficulty I have trying to explain to all of my members is why they cannot start their pumps and steal water out of the rivers, because they have to comply with rules. And these same rules have got to apply to the guys in the north.
Yeah. Now, Robert, we're just coming, sort of got 15 minutes to go. Do you want
I'm done.
Justin's got his hand up.
Yep.
You're done? Okay, thanks, Robert. Okay, Justin, you're next.
Hey, thanks, Mick. G'day, fellas. I'm trying to get my head around the volumes here. Obviously, we've got government saying 30 gigalitres floodplain harvesting, or 30 gigalitres taken over that period, a portion of which was floodplain harvesting. You're suggesting it's much, much more. I'm trying to work out what the truth is here, because I think it's quite substantive to your concerns, but also to the future of the policy area. Why are you so confident it is that much more?
Well, I would contend that the volume of the storage and the volume of water that went into it, by our interpretations of existing New South Wales rules and regulations, is that it is all considered under any act you want to look at, the Water Management Act, the Swamp, the Federal Act. It is a water take, and the regulation that was lodged on the 7th of February. Has created a new classification of water that Minister Pavey is calling passive take. Now, there is no difference between passive take. If you remove water from a paddock, from a stream, from underground, whether you flick it in with a spoon or a pump or it gravity feeds in, it is all still considered a water take. So what Minister Pavey and the department claimed was a 30 gig take is not actually correct. I would contend that there were 900 gigalitres taken into storage. None of it had works orders. None of it has a licence, most definitely, in the northern region, that needs to be better monitored and better reported, because it is really misleading and deceptive information to people like yourselves making decisions about rules that apply to all of New South Wales constituents.
your position is the vast majority of that take is happening passively, which is a berm or an embankment just sort of guiding water via gravity and impounding it to a degree. It might be subsequently pumped or it might be retained therefore or used later. And then that's the biggest portion of the take, is that right?
Exactly.
Justin, you're saying on
Someone might like to
someone's,
mute.
you just need to mute your phone. People need to mute if they're not on engaged. Justin, we missed all of that because of background music. Can you just re-say that for Chris?
I will. So I take from what you're saying, Chris, that the majority of the water that you think is taken under floodplain harvesting is actually under this passive take. There's some concerns I'm picking up about the definitions of that, but largely it might be a berm or an embankment or some other sort of works which just moves water or, via gravity transfers water into a sort of a temporary impoundment or something like that. That's the majority of the take you're concerned about.
Exactly. It's a vast area and they had heavy rain and it runs across the properties and it's guided into depressions where they've built walls to impound that water. Now, because it ran in there by gravity, it's like robbing a bank with a smile on your face. You're still taking something that's not yours, and there are rules that apply and specifically spelt out in all of the acts, as Tim has done with our submission, showing that water take, there is no difference. And that's the volume we're talking about. We're not talking about volumes that people have a license to pump from a river and all of the right triggers have been met with river heights and river flows. If they have a license, most welcome to pump. And that's what we would expect in our neck of the woods. It's worse than that. Our rivers are in flood because all of our water is urgently needed down South Australia to make up for the shortfalls that aren't coming down the Darling, but we're not allowed to touch it.
And from your perspective, that passive take water is still floodplain harvesting and is still required to be licensed. Are you concerned that this exemption regulation is effectively setting up a situation where the New South Wales government is going to try to regulate and license floodplain harvesting, but exclude that passive take component?
Exactly what the intention of the regulation is.
Thanks, Nick.
Okay, so I have one question before I go back to Sam. Earlier it was mentioned about NRAR and the impact of the regulation around the activities of NRAR. So either Chris or Darcy, can you just explain to the committee what was the impact of the regulation on NRAR's remit?
NRAR were present with the department when they went around last year, and they actually took on board what we'd been saying, that the intention and the policy of the proposed floodplain harvesting licensing, they contended that these people were actually breaking the law by taking water without a works order and were not actually compliant or able to get a license without a works order dated pre-3rd of July 2008.
Yep.
And that's what forced the minister's hand to put in place this regulation, and sold on the basis that she was going to put an embargo in place, which she lifted 2 days later when it started to rain. So they all took as much water as they wanted in any event.
Okay, thanks, Chris. Now, Sam, I know we're going to go back to you, and Kate's indicated she's got a question, and folks, that'll pretty much get us to the end of the time, I'd suggest. So, Sam?
Yep, I'll quickly try and get through. I've got a couple, but hopefully they're quick ones. So, firstly, to Chris, how have you been able to validate that water storage facilities on farm in the north are actually full?
Well, I fly a light plane. We've also got, and see it regularly, but we've also got a lot of satellite work being done that identifies clearly the size of the dams. Depths at this stage are still being calculated, but known depths would indicate the types of volumes we're talking about. And Darcy, there is another document you have that would indicate a volume of 4,200 gigalitres of storage in the north, if you'd like to add that.
Yeah, so that was the figure that I had there earlier, which was 4,039 gigalitres in turkey nests, and then a further, I can't remember the number exactly, but a further 239 gigalitres in other storages.
Yep, because we're running out of time, a question on notice, could I ask that you supply that information that your organisation has been able to validate that these storage facilities are full? Because from virtual site visits, department briefings, and some on-farm visits that I have been involved with over the last 6 months. I can't validate that. So I'd be very interested to see what data you've got and if that can be a question or notice to come back to us. Second question is around farms in the Murray, and they're required to obviously capture rainfall. And do you believe that that in itself is floodplain harvesting?
The only rainfall captured on farms is the reticulation systems, where we have irrigation systems, and any runoff can be recycled back into storage for reuse rather than run into rivers. But look, the types of applications of water through centre pivots and the types of soils, there is a minimal runoff captured. With what you're trying to allude is floodplain harvesting in the south, Sam.
Okay.
Just a very, very minimal.
Final question is to Tim. Interested about Aqualaw, and in some of the stuff that I have read in a bit of research prior to today that's publicly available in the media. So does Aqualaw, anyone at Aqualaw, have they ever contributed to discussion pieces or articles in The Guardian on floodplain harvesting?
Has anyone at
Aqualaw ever contributed in commentary or to articles in The Guardian around floodplain harvesting regulation?
It wouldn't surprise me. We're contacted all the time for our views on different matters of note. So that would not surprise me at all.
So that would be a yes in your view?
Well, it wouldn't be a no. I have no reason to say that we wouldn't have.
What's the relevance of this one, Sam? You seem to be worried about floodplain harvesting in a region of the New South Wales portion, like the New South Wales Murray, that has nothing to do with what's happening in the floodplain harvesting in the Northern Basin. I mean, you've got the MDBA compliance review in 2017 that said there's 3,000 gigs of unmetered take happening from river systems and from floodplains. And you want to focus on an area that's got 98% compliance. Mick, are we going to tolerate?
Yeah, no, we're heading off to Kate now.
Yeah.
Thanks, Mick.
Thanks, Chair. I think I've got a question that's actually relevant to the inquiry and the issues before us. I think this is directed to Tim. We've had some of the irrigators this morning. Let me have a look. It was the Guida Valley as well as Border Rivers Food and Fibre that were very much wanting to assure us that in fact, Border Rivers Food and Fibre submission says that we have been assured by ministers since 2008 that floodplain harvesting remained a legal permitted activity under the New South Wales Water Act 1912. And they particularly said how frustrating it was that some applications dated back to the 80s were apparently sitting in the department's filing cabinet. Such was the low level of priority put to them. Tim, why do you think that these applications have sat in department filing cabinets for more than 30 years? Could you care to comment on why these were in the submissions from Guida Valley and Border Rivers?
Well, it's something that I raised in my supplementary submission, says around it. Effectively, it's of great concern to SRI that people have applied and decided to just continue on and applied for works approval and then gone and done it without actually receiving a response. And especially people that are relying on these that date back over 30 years. And you know, the example was used, someone that applies for a job, wouldn't normally work in that job for 30 years before checking whether or not the employer had actually agreed to accept them. So I think it really emphasises the point of SRI and every single person who's submitting to this committee that there is a real issue here that we need to actually bore down into what approvals have been applied for, which ones have been granted, which ones haven't, make it transparent, and not provide a regulation that just gives a carte blanche approval to anyone and rewards bad behaviour. it's not a good policy for the New South Wales government to allow where I think referred to as it's easier to seek forgiveness now. Easier to seek forgiveness later than ask for permission now policy. That shouldn't be tolerated, and I don't think that would be acceptable to anyone else within New South Wales.
Great, thank you. That's me, Nick. All good.
Okay, thanks. Now I've got one probably last question. It's probably to Tim. So in the submission from SRI, point 17, and I'll just quote, it says, these consequences are not only matters of significant economic and environmental concern, but as a matter of law, also raise a very real question as to the potential invalidity or inoperability of the regulation. Pretty much that's the crux of this whole inquiry, really, there in that one statement. So, Tim, why do you say that?
Because the regulation was made pursuant to Section 400 of the Water Management Act, and the regulation needs to be consistent with the objects and purposes of the Water Management Act. And we would say that the regulation isn't consistent with that. An example is that I think it's Section 9 requires the Act to be administered according to the principles, as enunciated in the State Water Management Outcomes Plan, which is very specific with respect to no additional floodplain harvesting. It's required to be metered and measured and licensed, and this regulation does none of that. And so in any event, it was improperly made pursuant to the Water Management Act.
And just flying on from that, no pun intended, but earlier today we heard testimony, I think it was from John Marie Baker, but she was saying that, it was the New South Wales Irrigators Council, and they were talking about the fact that the regulation was made without following the government's own better regulation principles. Have you had a chance to look at that aspect of the creation of this regulation?
Certainly. I mean, we agreed with that that was put forward. I mean, a regulation of such importance and such public interest there should have been some consultation and explanation. Minister Pavey's submission also talks about that it was to provide clarity. I think that it's done the opposite. It certainly confused the issue, and we'd invite her to actually come out and express why, what needed to be clarified. What is the advice that she has, and why is she not sharing that with everyone and just pushing through these regulations that have no end date?
Okay, thank you very much for your attendance today. Quite thought-provoking. The committee has resolved that answers to questions taken on notice be returned within 14 days, and there were a number of questions that were taken on notice, and the Secretariat will be in contact with you in relation to those. And I think members you may have generated a few extra questions from members as well, so the Secretariat will get those to you when they're available. Thank you, Tim. Thank you, Chris, and thank you, Darcy, for your time and your assistance in this matter.
Thanks, Mick.
And we'll have to get you to leave the meeting so to bring the next lot in. So thank you very much for your time.
Thank you.
Thanks, Mick.
Bye.
Thank you.